All right, so welcome to the Search and Seizure Show. Zach Miller here, Blue to Gold. I am flying solo tonight. Nobody seemed to be, everybody seemed to have better things to do than join me to answer some of your questions. So I will give it my best. I've got a few questions here that folks have sent in, but let's open it up to anybody who's live. If you'd be willing to grab a mic and ask your question. You don't know video. You don't have to come on video, but it works out much better if you can ask your question, and we can kind of, maybe if I have some follow up, I can ask you that way. So anybody in the chat, let us know. If not, while you guys are thinking about that, I do have a couple of questions that people have sent in. So let me see what we have here. All right, while we're waiting on the chat, folks, here's one here. We got a question from Nevada. The question was, can I separate someone who's being detained in my patrol car from their phone? So he says, to give it some context, I've got somebody who's just detained. He's not under arrest. It's a Terry stop, and I've got him in the back of my patrol car lawfully. And oops, hold on a second. I have them lawfully detained in my patrol car. And so I go out and I go and I talk to other people, and I come back and I open the door, and there's the guy who's being detained in there talking on the phone. Of course, I have no idea who he's talking to. Can I remove the phone from that person? Obviously I'm not, we're not thinking it's a weapon, so I'm not concerned about it being a threat to me. And I think the answer is yes, absolutely. You've lawfully detained this person, so you have reasonable suspicion to believe they're involved in criminal activity. They don't have a right to make phone calls at this point during the stop. I mean, if I detained someone who didn't have a phone on them and they said, well, can I borrow your phone? I want to make a call. We would not, there's no legal obligation to give them access to a phone. And then taking their phone for this brief detention, the intrusion upon the possessory interest they have in their phone is minimal. You don't have a right to access it right now anyway. So my holding on to it as a police officer for a brief period of time is I think it's completely reasonable. Obviously we're not scrolling through the phone. We're and there is also a safety. We could also articulate a safety concern. I like the officer said in his question. I don't know who he's calling in the back of that car, and maybe he's calling his friends to come to the scene or his family members. So absolutely, I don't have any issue with it, and I think he was asking for some case law to support that. I don't have any particular case off the top of my head other than just it just seems like a reasonable thing to do. He's not necessarily committing a crime by having it. So yes, you can take their phone from them during a lawful detention. Okay. We got a question. Who is it? A Christian? Is that who we're? Christian, are you up? All right. I think is that. I'm sorry. Who are we doing? Yep. Okay. Christian J. All right, Christian. I'm gonna give you. I'm gonna bring you access in just a second. You gonna hear me?
Yeah, I can hear. Can you hear
All
me?
right. Cool. We got you. I apologize for that. I gotta. All right.
Okay.
So go ahead, Christian, with your question for everybody.
So it's gonna be out of Pennsylvania, so no vehicle exception. So it's more or less probable cause to believe there's drugs or whatever may be criminality in a car. Denied consent, gonna apply for a search warrant for the vehicle. My question is, with towing of the vehicle, once you're seizing it, you're gonna take it. Typically, the way it works is we would take it to either a secure lot or our station to have it secured prior to executing the search warrant. My question relates to, say they pull over and it's private property, so you don't have the tow based off of the blocking the roadway, traffic hazard, any of that. It's more or less is what's the legal backing if we were able to tow that car still. In my mind at least, it's been the destruction of evidence, but I've had discussions with other people that says that doesn't essentially matter to towing of the vehicle if it's on private property and there's no other reason to tow it. Pretty much our inability to have an officer, depending on manpower, sit on that vehicle, ensuring that nothing gets taken or removed, would not necessarily allow us to tow that vehicle.
No, I think the authority to, so we've got PC to search it. And I think, yeah, I think that the PC to search it gives you the authority to tow the car to conduct the search. For the very reason that you just said. We don't have the manpower to sit here and guard this thing while we run out and get our search warrant. So I think just because you can search it does not give you the authority to seize it. That's certainly true. But I think because of the exigency, if you will, of this particular situation, because you still have exigent circumstances that allows you to search a car, but you need true exigency
Yeah.
in that case. But I think the exigency of it not being practical to post an officer up here while we obtain the warrant would give us the authority, assuming we're on the property lawfully in the first place. So this is like a traffic stop where he
Yeah, you
pulls on the
say
private
so you
property.
you pull a traffic stop and they pull into a shopping center.
Okay, yeah, yeah. Well, that's yeah, absolutely. That's yeah, your probable cause to search it plus the inability to have someone sit there and guard that vehicle while we go get that warrant, I think would justify the towing in that situation. As long as we're on the private property lawfully in the first place.
That was
We
my understanding. That was my
yeah.
belief, and that's kind of how I've operated. But just I've had a differing of opinion from another quote unquote legal person that said
So
that our inability to have someone there does not allow us to essentially tow it. Uh,
so how are we supposed to prevent the evidence from being lost? The evidence that we have probable cause. I'm asking you rhetorically because you know the answer to this is, that's an exigency. If I've got probable cause to believe there's evidence or contraband in it, but I can't secure that vehicle to prevent it from leaving while I get a search warrant, that defies common sense to me to say that you can't seize the vehicle. If I've got probable cause to search a house, I can seize the house and keep people from entering the home um, to destroy evidence. And if I can do that with a house, then I can certainly seize a car, an area where you have a much less of an expectation of privacy than a house. So yeah, I'm not following the logic from the other person you've gotten advice from.
well, and I guess the point that that person was making is it's essentially the law or whatever you want to say, the what gives you the authority to tow the vehicle based off your or not tow the vehicle. Say you have like a Philadelphia Police Department where they have umpteen numbers of officers compared to some small borough in wherever PA. It
Mhm.
doesn't matter. The law still applies the same. And his reasoning was whether you're in a large agency that has the manpower or a small agency that doesn't have the manpower of the agency doesn't necessitate the allowing to tow it away from the scene, outside it being some sort of hazard.
I just have to disagree completely with that part. I mean, the fact that,
Agreed.
yeah,
Yeah, I mean,
yeah,
I
a lack
disagree as
of
well, but
resources. Yeah. Now, if we like, if we, yeah, the lack of resources can certainly create a type of exigent circumstances. I mean, absolutely. Yeah. I just, I don't know what else to say, but I just disagree with that. I mean, if you've got PC to believe there's evidence in that car, you have PC to maintain the status quo so that evidence doesn't disappear. And if the only option you have available to you because of manpower or how your department operates is seizing that car, yeah, I don't see any constitutional issue under state law or the Fourth Amendment. Yeah,
got it. That
yeah.
I
So
100% agree.
I appreciate that. And anyway, so a home, if anybody was the home seizure case is Illinois versus MacArthur. Again, if I can seize a house without a warrant, in anticipation of a search warrant, I can certainly seize a car. Yeah. So anyway, great question, Christian. I appreciate that. Alex, you should be able to talk now. Alex, you got us? You should be able to unmute and ask your question. Alex? All right. I'm gonna okay, having mic issue. If you want to, if your mic's not working, if you want to type your question in, that'll oh yeah, you can yeah, here, you can call. Hold on a second. Can you call in, Mike? Alex, can you call in? I'll give you my number. Alex, if you want to call me, we can do it that way. Here's my number. We'll give Alex just a second, see if he wants to call me. All right. Hey, Alex.
Hey, how's it going? Sorry about that.
No problem, no problem at all. What's your question? We got you.
So this is not really specific to Ohio, but that's where I work. I work as a patrol officer and then also a paramedic, two separate jobs. So we run into the instances here in Ohio. We obviously have the emergency admission for application for mental health. There's 4 criteria: substantial risk of harm to self, substantial risk of harm to others. There's also a box for you just basically they're unable to. We believe they're unable to care for themselves, and then there's also one where we believe that they would benefit from mental health treatment. The question I have is, a physician on like our medical control can actually order the paramedics in Ohio to take the patient in, which I'm assuming is nationwide, if they don't have the mental capacity to make their own medical decisions. Yes. Obviously, there comes the time there where there's going to be that person doesn't want to go, but the paramedics have been ordered to take them in. So they call patrol officers out there for help, obviously, and then it leads into a use of force and things like that. Traditionally, that emergency application in Ohio really doesn't get used just when it's a medical event like that. That's more for your suicidal, homicidal type ideations. I guess my question in general is, do you know of any case law? Obviously, I would believe it would fall under the community caretaking, exception. You're rendering aid, you're assisting medical professionals with that. But I was just wondering if you had any guidance on like if there's any case law and how you would articulate that, because I mean, we go out there and these people don't want to go to the hospital, but they've been ordered to be taken in. It's kind of a gray area we have in Ohio, at least, where there's not a whole lot of checks and balances, I feel like, on once you get them to the hospital.
Are you specifically asking about the number 4 when the doctor orders him brought in? Or all the, I mean, they all fall under community caretaking. Absolutely. All 4 of those criteria.
I guess my question more is like, so we'll get called out as like patrol officers because I work in separate jurisdictions. So there's times that EMS will call us out on the as the police, and they'll say, "Hey, the doctor has ordered us to take the subject in. They don't want to go." And obviously, we try to kind of use like CIT and get that person to go. Pretty frequently, we have success for that. But there's times where we essentially have to use force, or at least very passive force to get them to go in the ambulance. We have to ride, and sometimes it leads to handcuffing because they want to elope. And what I'm curious about is, we'll get them to the hospital and we'll turn them over to a higher level of care, like doctors, nurses, everything like that. But they don't fill out that emergency application. Once they're at the hospital, they just have them there. So it's more, I guess, is like a liability type thing. Do you know of any case law specifically with EMS or?
Yeah. So I mean, and Rick, maybe you can help me with this. It's been several months ago. Anthony did a webinar, a 1-hour webinar on medical detentions. The EMT, he had an EMT on there, and it was a really good webinar. Do we post these on the YouTube channel, Rick? Does anybody like old webinars? The one Anthony did a few months ago about medical, because he had a bunch of case law in there, and I don't, off the top of my head, I don't have anything specific, but it definitely falls under community caretaking. And
Yeah.
there is and there's a criteria that the doctor has to meet before he can order someone to come in for medical treatment. It's a pretty high threshold. It's higher than anything we would ever be held to. So if that doctor has met that, Brian Brian was the medic that was on. You're from Texas, I think, Brian. Is that correct? He's a medic who was on that episode with Anthony. So Brian, maybe is there any? The question is, the doctor has ordered the patient to be brought in for treatment, and law enforcement is tasked with helping to get this person in custody. I guess we're looking for a specific case law on that. I don't know that off the top of our heads we have any names, but we know it's a thing. We know that we have the authority to do that, and it comes under community caretaking. And if Brian says he's not sure about the case law, but Brian, is that something that happens relatively frequently in your EMT line of work? Brian is typing in on the chat here, where they're medically being taken into custody. He says it happens pretty frequently. But are you guys you're looking for something maybe for the doctor to like sign a form like after the fact saying I did in fact authorize this? Is that kind of what
I
you're
guess
thinking?
so this is just where like, so we actually don't even physically talk to the doctor a lot. So I'm taking all my factual evidence is coming from the paramedic on scene. They basically tell me, hey, this person doesn't have the capacity to make their own medical decisions right now, whether it be for a medical event. So like, I guess a pretty common one that we would see is we have somebody who has like an altered mental status from a head injury or something like that. They can't adequately tell the paramedics, where they're at or what their name is or the time of day. So they call a doctor here in Ohio and who's like the medical control. And the doctor says, this person cannot refuse care. So then they tell this person, hey, you have to go to the hospital. This person then refuses. They don't want to go to the hospital. So they call us out there and they say, hey, the doctor's ordered this person to be taken in. We need your assistance. And then
we are allowed to assume. So we have a medical professional who is telling us this person meets their medical criteria. We are allowed to believe they're telling us the truth, and we're allowed to believe that they believe they have met the criteria. So we're covered by the medical professional's determination. Like, you don't need like confirmation, don't need it in writing. You are allowed to believe this professional is competent to make that call. So if there ever was at the end, this turns into maybe we used some force and this guy got hurt, we're covered by our reasonable reliance on what the doctor is telling us, or in your case, the EMT through the doctor through the EMT. I would not worry about any liability.
Because it just seems like once we assist in conveying them to the hospital, it's like over with. It's just then and there. And, we've had patients jump out of the ambulance before and take off running down. So obviously we get called in and we're tasked with getting them back into custody. And so I guess more just looking for some insight, but just when it goes down the use of force continuum, that's what I was looking for. Is it enough based on what the EMT says on scene without actually talking to that doctor based on the Community Caretaking Act? And you answered that for me is yes.
Short,
based
sweet
on my
answer.
reasonable suspicion at the time that there is a medical issue, we can assist in that.
Short, sweet answer is yes. And of course, and we need probable cause because we're taking them into custody. So, And Sean says, he types in it should be under 5122 code in Ohio 5122. So maybe check that out. And if you do jump back on the chat, you'll notice Brian's got some good suggestions on the chat here. Check that out.
See that there. So I appreciate it. Thank you.
All right, thank you. All right. What else do we have? While I'm waiting for that, I'm going to go and check another email question. Here's a question from, not sure what state it is, because they don't list it, but we've got an investigator. Here, okay, this is a good one. Children and cell phones. The gist of this is, can mom and dad give consent? Christian Lopez. Okay, Christian, you're on deck. Let me answer this one real quickly, and then you got the mic. Can mom and dad give consent to search their child's cell phone? Give the police consent? Well, the answer is it depends. It depends on whether mom and dad have common authority over that phone, whether they have access to it as well, or has the son or the child, whatever, been given exclusive authority over that phone. I would think in a properly functioning family unit, we would not be giving the child exclusive control over their phone. But here's things courts look at to determine whether parents can consent to a search of their phone, child's phone, even over the objection of the child. Who bought the phone? Who pays the bill? Do mom and dad know the password to the phone, or how to get into the phone? Do mom and dad from time to time actually access the phone? So that's the analysis that the court's going to do. From all the totality of the circumstances, does it appear that mom and dad have authority over that phone or access to that phone? And if the answer is yes, then they can consent over the objection of their child because of their status as the parent. There's a hierarchy of authority there, and mom and dad are supposed to be at the top of that hierarchy. But if they give the phone to the kid and they don't know the password and they don't have any access or anything to do with it, then no, mom and dad probably could not consent to a search of the child's phone. All right, Christian Lopez, you are now able to talk. So go ahead whenever you're ready. Christian.
Can you hear me?
Yes, we can. Thanks for, what can we do for it? What's your question?
So I'm here in Texas and I have more of a three-part question.
Okay.
So when it comes to probable cause searches in the vehicle, and also when it comes to Terry frisk, Terry searches of vehicle of persons. So the Supreme Court has ruled that people are not containers in the vehicle, therefore they're not subject to search when you have probable cause search of vehicle, correct?
Correct. Yes. Correct.
Okay. So so when it comes down to Terry frisk, I see it a lot of time. I think it's common practice within law enforcement to conduct a Terry search of a subject whenever we remove them from the vehicle. Again, it's common practice. So is that lawful or not? Because
Yeah.
I'm under the belief that you cannot conduct a Terry search unless you believe that that person is armed.
You are correct. Right. To frisk someone non-consensually. So we can always ask. You can always ask, and most of the time, if you ask nicely, people say yes. But to frisk someone without their consent, you're correct. You have to have a reasonable suspicion to believe that person is currently armed and dangerous. And just because you're ordering them to exit the vehicle does not give you a reasonable suspicion to believe they're armed and dangerous. Now, I will say most courts seem to be of the belief that if you have at least reasonable suspicion that there's drug activity going on, like in a car, or in your case, probable cause, then that is enough to believe the person's armed and dangerous. That is enough to justify a frisk of a person, but not just because you're ordering them to exit the car. And I think I do see a lot of officers think that if you're getting out of the car, I have the authority to pat you down, not without consent and not without a reasonable suspicion to believe they're armed and dangerous.
Gotcha. And then my next question is it follows up on the probable cause search of the vehicle. So I mean, and it may be a stretch, but if you don't have, well, I mean, if you have probable cause to search a vehicle, but you can't search the person because they're not a container of that vehicle, I mean, could you justify that as exigent circumstances that that person may have any type of contraband on their person, and
So,
they may get rid of it or something like that, or what?
so the exigency is what forgives the warrant requirement. So exigency comes into play as to determine whether I need a warrant or not. You still need PC to believe the person has evidence or contraband on them. Now here is where different states have different, they've come down on this issue, particularly with drugs. There are some states, and I'm pretty sure Texas is one of them, that said if you have probable cause, and I'm trying to pull it up on my my notes here. If you have probable cause to believe there's drugs in the car, depending on where that probable cause comes from, that may be probable cause to also search the people. And yeah, so all right, so in Texas, a dog alert is probable cause to search a car, and it is also probable cause to search at least the driver. And the case, and so the case is state versus, I'm sorry, Branch versus State, I think is the name of the case. Branch from 2011. And also, if you smell like marijuana coming from the car, if the officer smells it, that is also probable cause to search at least the driver, and that's State versus Garza, 2017. Now, I might have those two backwards. Garza might be the dog case, Branch might be the person case. But Texas is one of the few states that has case law that says, basically, if you've got probable cause to believe there's drugs in the car, that is also probable cause to search at least the driver for those same drugs. That's contradictory to law in other states, like Virginia, for example. You need more than just there being drugs in the car. And the reason you can do it without a warrant, why you can search them without a warrant in most cases, would be exigency. It's not practical to think that I have to leave the scene to go get a warrant to come back and search the person. So Texas is kind of unique. I think Florida has, if the officer detects the drugs, like he can smell it, he can search. But if the dog alerts, you need more than that, because the dog can hit on residual odors. So it's state. This is where states deviate. I don't think the Texas case is correct. I think the Supreme Court has made it pretty clear that PC to search a car is not by itself PC to search people, but other states disagree.
Gotcha. I appreciate you.
So did we get? So you had 3 questions. Did we had the frisk? The first question was PC to search a car is not automatically PC to search a people. Is that correct?
Right.
You answered that, and then the question about exigency.
Yeah, that
You get
you kind of hit the no.
And did
Oh,
you get
thank
those
you.
2 cases, Branch and Garza?
Yeah, I got those already.
Check those out. And I might have gotten them backwards, but one's a dog and one's the officer detected it.
Okay, thank you.
All right. Appreciate you. Thanks, Christian. All right. Let's see. What's up, Anthony?
Well, look, I just want to say hello. I appreciate you you covering. I know we're almost probably winding down here, but I had a few minutes to say hello. So how are you doing?
Doing well. Yeah, we've had some good questions. We've had a couple on the mic. I got a couple email questions. I think I got one left. If you want to, actually, left. Let's see here. Do we have anybody in the queue here, Rick? I haven't checked the.
Hello, Teresa.
Let's see. All right. Here's a question. We have it's out of California. Traffic stop. Vehicle has a husband and wife in it. Husband is on a probation parole 4th waiver.
Yep.
We are searching the vehicle, registered to both of them. There's a purse in the vehicle between the 2 front seats that is unzipped. Do we have a reason to believe the husband could have discarded contraband in the purse, therefore we can search it? Is the question. Basically, can we search it because the husband might have put contraband in the purse, is the question.
All right, here's my answer. You tell me what you think. Okay, so let's first of all talk about probation, parole and probation searches in California, right? So they're based on the need to, control the the probationer, right? They don't require reasonable suspicion in California, which is great. It's nice to have it. Most states don't have it, something like that. And the terms usually say, and the case law says that you can search those things which the let's say parolee or probationer has common authority over, right? So, their bedroom, the things that the common areas that they share with others, and so forth. So the question here is whether or not it's reasonable to believe, right, to have the apparent authority that the probationer has a common authority over. It's the wife, right? You said wife or
Yeah.
girlfriend?
Wife.
Yeah, his wife. Yeah, has common authority of the wife's purse. If we do not believe that the person has common authority, then you're going to need probable cause, because the problem with the question is the way it sounds is like, it sounds to me that the cop wants to search the purse just because it's possible that the person put contraband in that purse. And I don't think that's correct. I still think you need somewhat common authority. But
Yeah.
there are some pretty good cases in California that
He,
talk
he,
about this issue.
he mentioned a case, People versus Maxwell, but I don't
Yeah.
have a citation, so I didn't have time to try and research this People versus Maxwell. He says, per People v. Maxwell, do you believe it's reasonable to believe the husband could have discarded the contraband? I still think you need that reason, that golden rule 3, right?
Yeah,
Probabilities, not possibilities.
that's right. You need something more. I mean, look, I think that comes down to this, right? If me and you are in the same car, and let's say it's my car, so and I'm on probation, and I have searchable conditions, and your backpack is by your feet, is it possible that I could have put drugs in your backpack? 100%.
Sure. Right.
Can the cop search your backpack because you're hanging out with somebody who's on probation? Absolutely not. Absolutely not. If they go through your backpack with those facts, they violate your rights. Would you agree with that?
Absolutely. Right. You're the one with a waiver, not me.
Correct. So in order to get into your backpack, we're going to need one of two things. Either one, the cop establishes that I have apparent authority of your backpack, which with those facts I do not. Or number two, we have probable cause for the backpack.
I agree. Yep. I think that is absolutely the right answer.
Yeah, and I think some of these cases, though, some of these cases, we know California case law is very, surprisingly, it's actually really in favor of the police officer, as far as searchable, and it may give the impression that all you need is a possibility of access. But I think if you really read the case and you understand what the courts are looking for, in those cases, it wasn't just possible; it was that the parolee or probation had some kind of common authority.
Because you can't be, California can't grant greater authority than the Fourth Amendment, obviously.
Yeah. Yeah. Now look, Ryan says, do we even have enough to search the whole car if the officer, if the passenger's on parole? I think the answer is actually yes, to some degree, because they're lawfully present. I mean, I've seen cases like that a ton of times where the being lawfully present in the car, oh man, I mean, I think that the courts usually uphold those. I know California cops do it all the time.
Yeah, I mean, this helps that it's husband and wife. I'm presuming it's both of their car, but doesn't.
Oh yeah. Okay, this case is even easier.
But
make
it boyfriend girlfriend.
Or let's go back to me and you as the friend.
Yeah.
I think the answer is yes, right? I think that I know that the cops are doing. I know that if I'm in your car as the passenger and I'm on searchable conditions, the cops will get me out of your car and search under my seat, search. Yeah, it's interesting though, because I know that they do it, but is it right? I think it is right. I think they have some level of control over that space.
Yeah, and so it's different than the backpack that's exclusively mine.
Yeah.
Versus the car that I'm allowing you in my car,
right?
Granting you some degree of authority over the common authority. So yeah, I can see a distinction.
Yeah, it's just a little different. It's a little different. It's a little different level of authority. Being in my car, sitting in my seat, being right next to the center console is a little bit different. I'm not saying the center console is fair game, but being, especially under the seat is fair game versus your backpack. Okay.
Sean cited People versus Maxwell here in the chat. That might be it, Sean.
Yeah, I'll try to find out later. And just make sure, it talks about what we're talking about here. But anything else?
This one goes to what we talked about today. This is an inventory search question. Don't have a state or an agency, but simple, straightforward question. We are towing a car, but not, and the driver or the owner of the car is present, but we're towing it, not charging him with a crime. So maybe it's maybe he doesn't have a license, and we're towing the car. Do I inventory the vehicle before or after I release them to gather their belongings? So basically, I take the
Oh.
question as, do we have to let this guy have an opportunity to get his belongings out of his car before we inventory it?
Man,
Uh,
that's a great question. Have you attacked this one yet, or
we have not. No, we talked about inventories and the basis for towing it, but we didn't talk about the scope of the search really.
Yeah. So my my advice on this has always been to just be reasonable, right? I mean, if if the tow truck is en route and they want to grab, they obviously want to grab their purse, their backpack, their laptop computer, their laptop bag. I believe that they have the authority to grab that. I think that if we're going to say no, you do not get to grab your bag until I search it, until I inventory it, or a lot of cops will say until I make sure that there's no gun in there. I think that before, as a government agent, before you start going through people's stuff, you need crew, you need their consent, you need a recognized exception, you need a warrant. If all you have is an inventory, then it's all based on community caretaking, which is obviously the topic that you talked about today. And community caretaking requires good faith. And if you're saying that I just want to do it to make sure there's nothing in there, that's not really why we do it. If you're saying that's the way I do business all the time, that's probably not what they're looking for. They're looking for some reason of how you are helping this person or you're protecting yourself against claims of damage. And so if they want to take the very thing from you so you don't have to be responsible for it and they want to take their property, the community caretaking rationale has already been justified. It's already been accomplished. The property is in good hands. It's in the owner, and it's in the owner of the property. I don't see how we can go through it under inventory, not with those facts. I think they should be allowed a reasonable amount of time to go through to grab stuff out. Now, at the same time, Zach, I've had cases where, a lot of our clients, a lot of our customers in law enforcement, they have a lot of stuff in their car and they're hoarders, right? And, I need about 10 minutes to inventory a car and the tow truck is like right around the corner. At that point, I'm like, look, you guys are done. I need to kind of get in this car and do my job. I'm not staying there forever.
Yeah.
I gave you time to kind of grab your purse and stuff, get out, and I'm going to call it. I think the courts will uphold that. We don't have to give them, 30 minutes to grab all their stuff. But I think that the courts would want to know if you're not going to let them grab their stuff, they would want to know why.
Have a good reason for that. Yeah, and I agree 100%. If there's no reason why we can't let this guy have his stuff, what purpose are we serving by denying him access to it? What community caretaking purpose? And I don't see one.
I'm looking at my phone right now, and I don't know if there's another case in the meantime. What's with Charles is from Brevard County. I don't know if he has anything, but so, and do you see Ryan's feedback too? Do we answer that? I'm trying to look for
Ryan, I think, was going back to the probation. He says if the car doesn't belong to him, wouldn't his probation status authorize intrude upon his privacy and property, not the driver? Yeah, I think Ryan, I agree with that. Like I'm the driver. I'm not the one on probation or parole. But I think the way courts probably look at it in California, because this is a pretty common occurrence, is that you're kind of I don't like to use the term assuming the risk, but you're theoretically assuming the risk by giving a ride to this probation or parolee who's on a waiver that, if we get stopped, I think parts of the car, I don't know that we can be rummaging through the trunk, but at least the area where the probation or parolee is sitting in a car, I think courts are likely to uphold that as an area that the probation or parolee, has some degree of authority or control over.
Actually, I think that's good. Look, actually, what's funny is I was just looking at my little database here, and I found two cases, including Maxwell is actually part of it. So I didn't know the case by name, but I did save it for reference. But I want to share two cases. Number one is there was a case called, I'm going back to it because I had two cases I want to share with you. Yep. Okay. So this case is called Claypool versus Superior Court of Sacramento County. It's a 2022 case. And hold on one second. Hopefully you can hear them in the back. I'm on family vacation, as you know. That's why you're covering for me. So if you hear the family laughing in the background, that's because they're getting drunk without me. So this was a case where the the officer had a passenger in the back who's on parole. And he searched a locked glove box and actually found a gun that, and then pinning it on the parolee. The court threw it out. They said that the parolee did not have independent access of the vehicle, did not observe anything suggesting that the occupants were maneuvering to get a gun and put it in the glove box. There was no, nexus to that glove box when it comes to the parolee. So I think that's a good point, is that, just because you're in a car and the parolee's in the car does not mean that you get that whole car. You do not own that car just because the person's on searchable probation or parole. But then you have Maxwell, which says, one second here. Yep. Okay, so Maxwell is that, let me see, it's a case from
88?
2000. No, actually, so I guess that wasn't the right case that Sean found. This case is from December 11th, 2020.
Okay.
And I have the citation too if you want it, but Maxwell 2020.
I get that. Yeah.
It's a California appellate. So it says basically the rule here from the court is, upon finding that the passenger in a motor vehicle is on searchable probation, an officer may search those areas of the car's passenger compartment where, so far so good. That means if I'm in your car, we talked about this, where the officer reasonably expects that the probationer could have stowed or discarded items after noticing police activity. The fact that the probationer had just left the car when contact is relevant. So he got out of the car, tried to play that game. At least so long as she is still so close to the car that she still continues to have access to it. An officer's good faith belief that the suspect is subject to a Fourth Amendment waiver justifies the search, even if later determines that the fourth waiver was invalid. So this was a case too. I remember this case where I think that Maxwell, if I've got my facts straight, Maxwell actually told the cops that he was on searchable probation or pro, whatever, and then it learned later that he was actually off of it. But of course, when you tell the cops that you're on searchable parole or probation, they can run with that, even though they should try to verify, but that's what the facts of the case. But I think, that's not the whole, that's just a summary, Zach. But would you agree that that is a form of common authority? Like that's a form of authority over that little area.
Yes. Yeah. And now that makes the question that was asked about the backpack and the wife, husband, wife, or the purse, the husband, wife, it makes even more sense. Yeah, I think it's more than just he possibly could have put it in there. He possibly could have put it in there and he had some kind of control over that area.
I think it's reasonable to believe, though, that I think there could be a presumption that a purse may be fair game for the husband, because it's all about apparent authority, not actual authority in California.
Yeah.
So I think that it is fair. It's reasonable to believe, right, to use your, that the husband may have access to the purse. Oftentimes spouses do go through other spouses' purses to get credit cards, car keys, house keys, and so forth. I think that's a factor, but what do you think about that? Is that, you think
so
that's
reason to believe he may have access, or reason to believe he may have put something in there? Those are two different things.
Well, I think it's both, though, right? I think
you would need both.
Right.
I think, yeah, but I'm gonna look at that Maxwell, since he cited it and you
but I think but I think what I'm saying here too, though, is that I think there's this logic in California where you almost like, if you have reason to believe that they put a gun or an item in that glove box, you're also articulating at the same time some kind of common authority, because they're indicating to you that they have access to that item.
Yeah, by putting it in there.
By putting it in there, right? That's part of their control.
Yeah.
So I don't know. I think it accomplishes the end goal. I think it's the same thing. It's just by making that presumption that they do have access, but maybe I'm wrong.
Doesn't sit well with me, but
I know it's a little bit of stretch. Look, I think at the end of the day, we agree that if you're going to search a space, it's either their actual authority or they have some kind of common authority.
Yes.
If you don't have that, then I think you would need the more traditional rules like probable cause or reasonable suspicion for a protective frisk.
Correct. I agree with that 100%. Yep.
Okay. All right, good. Anything else?
That's it. That's all the questions I had.
Okay.
And I don't see anybody else lined up in the mic here, so I think we're
all right. If anybody else has any questions, let us know. But I'm glad I had a few minutes to spend with you, Zach, and I appreciate you doing a great job. And Sean, I still respect you, even though your research skills are garbage. And I think that the fact that you tried to help is really what we let's see what Alex has. Even though Sean is one of my is a great instructor from Iowa, and he's let me down for the last time. If you are called to an overdose or some sort of medical issue where someone is unresponsive, would you say a Terry frisk is reasonable as an aid of being rendered? Oh, we have your answer here. We all know the subject are sometimes violent in these instances once waking up, especially when they are surrounded by or in a different place. I get it, right? Surrounded by police. This is obviously a case by case. However, is drug use is suspected. I would believe a Terry pat would be reasonable for everyone's safety. Okay, what do you think, Zach? What's your
My initial response is not without more than that. But if if he's articulating it pretty well, I mean, Terry goes both ways. If I have a reasonable suspicion to believe the person's dangerous, right? Therefore, I can frisk him for weapons. And I think, somebody he's talking about experience with people who are overdosing, who come out of it all of a sudden and react violently. I think if you articulate it like that.
Yeah, I want a little
Convince
bit
me.
more. I mean, I
Yeah.
don't want to go out there and have cops thinking that people who overdose are armed and dangerous, Um, but I think that's relevant. The fact that people that overdose and come out of this stupor, whatever you
Yeah.
call it, and they start fighting cops and stuff. But I think they're going to want.
You're gonna want more. I'd hate to. I'm hesitant to say, and I'm not saying like as a rule of thumb you can always do it. I mean, yeah, you need. What do we know about this guy in particular? I mean, let's
Now,
But,
no, look, I think that look, it doesn't take a lot of proof. I think you're right about, it's only reasonable to, reasonable suspicion or reason to believe that this guy could be a armed and dangerous, a danger to officers.
Mhm.
But the other thing about this, Zach, is what about, I call these cause of injury searches, right? They're really community caretaking, right?
Yeah.
So
yeah.
you have a person who is unconscious, and it's not really apparent why they're unconscious. I think you also may be able, and I know you can do a limited search to try to find the cause of injury.
Yeah.
That could also solve your problem, right? While you're searching for the medical alert bracelets, identification is part of medical treatment, knowing who these people are, a history and so forth, finding the means of injury, or did they overdose on fentanyl, methamphetamine, heroin, horse tranquilizers, whatever it is that these guys use out there. And then you share that with medical staff, but also at the same time, you can see if they have a weapon.
Yeah.
That might help too.
I think you could go attack it either way.
I got one more. Can I go do? Well,
Yeah.
well, I think the last one I was going to say is, you may also have. I mean, this is kind of a stretch here, but you also, since we talked about community caretaking, you also may have this. You may have an involuntary commitment in a sense, but that's not really. But if you, this is probably a stretch, but if you are thinking, hey, this guy is like an involuntary commitment, then that's a quasi arrest under state law. I mean, constitutionally, it's an arrest.
Yeah.
It's a civil arrest versus a criminal arrest. And you may also be able to search them because you are basically taking them in state custody. But I think you need an officer saying that, yeah, that's what we're doing. Under our law, we're doing a Baker Act, or we're doing a 5150 California.
Yeah.
But I'm just throwing it out there as for dialogue. So
yeah. I like it. All right. We're good. Yeah.
All right. Well, hey guys, thank you for joining us. I really appreciate you. Again, Zach, thank you for covering me while I get drunk with the family. I really appreciate you guys. I needed a little break. Good to see you, Sean, in spirit. All right, guys, I'm gonna head out. Zach, thanks again.
All right. Thanks a lot. Good seeing you. Enjoy the vacation.